We're going to go ahead and start the panel discussion and Q&A session. Here's Professor Lange.
Well, in my role as a potted plant, what I propose to do is simply tell you what we propose to do, and then I'm going to sort of sit off to the side and absorb nutrients. We're going to start with Steve, who will respond to the things that were said after he spoke. And then I will count on the members of the panel, who seem to me to be eager and lively, to do battle with each other along lines that we can all anticipate. And in about 30 minutes or so, maybe 40, we'll open the floor to everyone here in the room. You'll find at that point that these little mics in front of you will go live, and you can speak and be heard. But we'll begin first with Stephen and a vigorous rebuttal to the things that were said toward the end of the presentation.
I'm in trouble now. In truth, I think the underlying messages that both Jim and Jason were delivering we're in violent agreement over, which is essentially that music should be made available to consumers in as many ways as possible, and utilizing all kinds of different technologies. And record companies are doing that. There could be arguments about whether, they've come to they should have done it a few years earlier than they have. But there are plenty of alternatives that are out there now, or other services that will come on board in a matter of time once the companies that are actually going to be delivering them have put together all the technologies, et cetera, that the record companies have already licensed. And that includes P2P services. I mean, there are several that have already been licensed: iMesh, World Media, Grokster, and these things will come on board. And I think every one of our members is in agreement that users should be participating. I think the issue is, and this is where I had some confusion with Jason's presentation, was that you started out by saying should only be legal uses, but you kind of ended up in a place by saying they should be allowed to use P2P because of user participation, and the lawsuits are bad because of it. The lawsuits aren't designed to stop user participation. They're designed to have user participation be on legal sites, not illegal sites, and to move people from places where licenses haven't been obtained to places where licenses have been obtained. That's what the lawsuits are about. And call it a sad commentary, if you will, on our society, but frankly, the only thing that works in this area is that kind of deterrence. We tried educational messages for several years. People don't respond to that. They respond more to knowing that there is a risk that they're going to be sued and they're going to have to pay according to what the law says they have to pay for copyright infringement. That's ingrained in our culture, and I think in a number of ways, and it's something that just is kind of a truism, unfortunately, and is therefore a reason that we engaged in that. So the lawsuits have actually been tremendously helpful, because if you look at polls before the lawsuits and after about whether downloading was legal and whether it wasn't, or who was downloading and who wasn't, there was a dramatic change, a sea change in public opinion about understanding what downloading was and when it was legal and when it wasn't. It has completely served its purpose in that regard, and it's part of an overall educational effort. It's not designed to stop people from participating in music. Record companies, artists, everybody wants people to participate in music. They just want them to do it on legal sites and not on illegal ones. I think the model that you talked about afterward, about essentially moving to a compulsory license for some kind of P2P model, the problem that we have with a compulsory license kind of model is that who sets the rates? You have some government entity deciding whether a Bruce Springsteen track is more valuable than a Kelly Clarkson track. This is not how the market is supposed to work. The marketplace is supposed to take care of how works are valued. There's not an issue here about licenses being made available. The licenses are available. You move to compulsory license schemes when licenses are not available. That's not a problem. Services are getting the licenses they need, and there are services that allow people to actually trade the files themselves that they're trading, where they get points and things like that. Those are all either already available or about to become available. So moving to a situation where you take away variable pricing and the marketplace elements about how music is valued isn't a solution that we would agree with. And in terms of all the discussion here about DRMs and the quotes, I think Jim, the quote you put up there answered it itself. What Don really was saying was that there are, this is authorized. He was saying it's lawful because it's authorized. It's the same thing that we've said on the website. It's the same thing that's there. In one sentence in the course of a Supreme Court argument, then he wasn't asked to explicate that anymore, but there isn't any inconsistency between the positions. We could debate a lot about, take the rest of the time on, going through the 4 factors on whether it's a fair use or not. The Copyright Office feels otherwise. No court has held that it's a fair use. And so...
but why isn't it? Why is it not? In one sentence, why is it
well,
not?
the problem is you can't say it in one. It really is.
Can I interrupt for a second on a non-debate point?
Yeah.
I just want to turn this off. I don't want people to be distracted. I just
Oh.
want to see that I do care about Steve and love seeing those numbers. So you take the thing up.
But the thing here, this is it shouldn't be a debater's point here. We could debate that for a long time, but. It's interesting that the music industry, which has the most liberal rules with regard to making personal copies, is the one that's under attack. Other copyrighted works, other content industries, Jim's clients in the software industry, much more restrictive in terms of the kinds of copies that you can make. When you get an operating system from Microsoft, you can't make all kinds of multiple copies with it, like you can for personal use for music. So the bottom line is there's no issue about people making it. The major record companies at least have made that clear. The use of DRM, as Jim was saying in his presentation, is an important part of continuing to create music and for innovation to be there. I think the only other point I'd make at the beginning, I guess, is to, you have to insert a certain level of common sense here. And I don't think you were saying, Jim, that piracy, physical or online, hasn't affected sales.
No, it's a question of degree. It's a matter of degree.
Okay, well, we can argue about degree, but there's no question but that it's affected it. And there's basically been one study that's gone that said it hasn't. Every other study that's been done, which are multiple studies, have said it has. Now we don't have to get into no one's saying it's a one-to-one but-for kind of effect, but there's an obvious effect there. And I think it's misunderstood that our industry thinks that no one's to blame but P2P file sharing. There's other forms of piracy, like you acknowledge, on the physical side. There's changes in people's tastes and business models and things like that. It's an overall problem. But at bottom, I think we're in agreement in terms of trying to use technologies to make music more available the way that people want them, want music. So.
No, look, I wasn't trying, and I did start by saying I think peer-to-peer unauthorized downloading is wrong. I think the question is when you look at all of the other problems, and I lump physical piracy into that. To me, that's a one-for-one, virtual one-for-one. There, people are shelling out bucks for music. So to me, that's one-for-one. Put that in the bucket. I agree that's a leaky sieve. Number two, the actions that the music executives took in '98 through 2001 of cutting the artist rolls. And I went to lots of music events and symposiums. So listen, they're all complaining about all the money they had to pay to the radio stations to get play, all the promotion, and they needed to cut out the bottom third of that triangle, and they needed to raise their prices. And on top of that, you had DVDs going nuts. You had game software. You had all sorts of stuff that was really increasing, not exponentially, that's a little too much, but doubling, tripling in sales to the same target audience. To say that peer-to-peer is the major cause, that's the problem I have, is saying it's the major cause. Did it have some effect? I think it had more effect of diversifying tastes than diverting sales. I just can't say for sure that it diverted any. I can't say it didn't. And I'd like to see a study that, and I'm not saying you're right, there was one study that was an empirical study. Every other one's been a poll. I've not seen them. I'd love to see, send me an empirical study and I will eat my words. Not the study, it's too big probably. But there are some studies I don't understand, I have to admit, and I thought they looked like polls. But the point is that there isn't certainty. I can say with certainty that physical piracy affects sales. I'm pretty damn certain, because it affects every other business I know, maybe the record industry is different, that when you cut your inventory you cut the number of releases by a third, and this is in the 98 to 2000, not after the sales really started declining, plus you raise your prices in that same period 10.5%, you tend to lose sales. I'm not saying it doesn't make peer-to-peer right. The question is, what do you do about it? And again, and Jason may have more to say about this in a different way, but I would never say don't exercise your legal rights to sue people. I mean, that's your right under the law. My only criticism at the time, and I got into trouble with Carrie about it, who I guess your boss, right? Carrie Sherman, who's a wonderful human being too. I don't know, they hire such good people. I hate arguing with them. Really, I'm serious. I don't mean that in any. I really like them. They're great to go to dinner with. But the point is, and we don't talk about these things, otherwise it would ruin your appetite. But the point is that I think it's the last resort. I think that until if they had forsworn the enforcement, got lots of this stuff up. I don't know whether we're at that tilting point. Lots of education, and then started suing people. Maybe I might feel differently about it, but that's not my judgment. I'm not going to say don't sue people, because that's your right. I mean,
well, iTunes was up before any of the lawsuits started.
It was sort of the. Look, you got to get it. It's not just up. It's like it is today. It's got to be robust out there. Again, this is my personal view.
If I could
But
just
the problem with that is the longer you wait, I mean, you've got, as it is now, you have a certain age demographic that is conditioned to getting music for free. The longer you wait and the more that demographic spreads, the worse of a problem it is.
Let me actually jump in. And this is what I'm saying. I think that, well, one, I think you've lost that battle. To be quite honest, I don't think you'll ever convince them to go back to CD buying. But the thing is that the way you describe, we do have business models coming out that involve users where users can participate. I actually don't think you get what I'm saying. What I'm saying is the idea of purchasing a song is not user participation. That's not what I'm talking about. I mean, putting DRM that constrains people so that they can't even make what are fair uses in many people's minds, that's not user participation, right? The ability for me to buy something from you is not what I'm talking about. And all the services, including iTunes, are very restrictive in a lot of ways.
Well, what about iMesh? That's exactly what iMesh does. It's a completely community-based
Can I rip my CDs and put it on and let other people download them?
Can you rip your CDs, put them on, and let other people download them? On iMesh? No, you can, all music.
That's what I'm saying. Like, in other words,
But well,
I mean, so let me just address a couple other points, and we can go back and forth on this. The other thing is that you all notice that Steve's a very, very good lawyer because he didn't answer my fair use question. But in addition, he also took the slide where I said there are options which are voluntary and compulsory, and then I said EFF's suggestion is a voluntary license, and then he talks about compulsory licenses as if that's the solution. So just to clarify, we're not talking about a compulsory license, which is one that's enacted as a statute. Although I will point out that, in fact, you guys are probably one of the biggest users of compulsory licenses that do have a government-mandated price tag on them of 8.5 cents per copy per song.
9.1.
9.1, right. I'm sorry, I forgot the update. But and so I mean, I think that bickering with that sort of a model is a little hard for you to do when you depend on it. If you are willing to waive that and get rid of it, then maybe
the difference is that the publishers don't and the songwriters don't want to waive it.
What?
I
mean,
so it's
but the point is
that
that is a model that you guys depend on and use, and it's also not the model we're proposing. The one that I actually think that the market could set the right rates, that the licenses for legal use of music through peer-to-peer and other kinds of technologies that are not constrained to a single vendor such as iMash or something else, actually could be set by what people will pay. And so I don't think that there needs to be a set rate. The last thing I'll say also is that in terms of making licenses available, he said their licenses are there, people can get licensed. I think the honest response is that they can get licensed if they also agree to a lot of restrictions, right? That there have to be certain DRM restrictions, there have to be certain restrictions on making certain songs available in certain ways. It's more than just you pay to play. There's a lot of other things that come with it. And what I'm talking about is a more free license, one where you pay, but then there are a lot more flexibility options in terms of what the vendor can do with the music, who they can give it to, what the users can then do with it back on the system. And the services I was talking about, Flickr, YouTube, and those others are ones where they really are trying to give as many sort of free options as possible. And so I do think there's a qualitative difference.
I don't think any record company has said no to exploring those things. I mean, that's kind of the underlying assumption that you're making in your presentation, where virtually every maybe there hasn't been a service that's come to them with that model to get licensed. I mean, if you can point to services where it's been turned down, that'd be one thing. That's just simply not the case. Every single service is essentially licensed.
You guys should start one.
Steve, can I get back
There
to
you go. That's the way to get out of the lawyer business.
I do want, I haven't spoken much about legal issues, but I do want to get back to Don Verrilli's statement and the RIA statement. No, seriously, this is a serious legal question. Does the RIA and Don Verrilli have the authority to bind every producer of every CD for all times, to authorize people to rip them?
Well, of course not.
Well, then you're guilty of inducement. No, I'm serious.
He said on behalf of my client.
No, the RIA site doesn't say that.
It's very
Oh, no,
clear.
I shouldn't have said that. It's going to be
Very
changed
clear.
tomorrow.
Very
No.
clear who the RIAA represents.
Does?
Who's up there.
It is?
So, yeah, it is.
I don't know.
And it's also on the Music United site, which lists all of the people who participate. So it's very clear who's making the statements.
Oh, okay.
But Don was very clear. He said, on behalf of my clients in the case, and he was representing, the named
Didn't say
record
that.
companies.
I admit he didn't either say fair use or authorization. The way that most lawyers I know took it was fair use, and maybe that's because that's what they wanted here.
Well,
But
then
he didn't
it's a good
say.
thing we clarified it in the last.
Well, it's a good thing. I'll have to tell Steve Metalitz he did a great job of clarification of Don Verrilli.
That's
You
it.
guys have been
I was
quiet.
just,
You're
I-
talking.
I've talked.
We'll shut up.
I'd like to get James's input on this too, but ever since about 98 or 99, every time I'm at a conference, I always hear people who are against file sharing, who think it's wrong, who think it is copyright infringement, but there's not anything you can do about it, because there's not. It's just growing exponentially and continues to. And yet, the point of view that you guys are both saying is that you're in favor of compensation. Leslie is in favor of compensation. And we're going to figure that out. But meanwhile, nobody's figured it out. And I am attracted to your idea of the white paper. I've read your white paper. Fred gave it to me at a conference a few months ago, a voluntary levy system. But I come back to the point where unless copyright holders, artists and their investors, financiers, unless they have a copyright that means something, how are they ever going to even get to the table to negotiate it for a levy system? How are they ever going to be, if you're talking to profitable other businesses that are making their iPods, they have their ISPs, their websites, all the various people that are making money off this swirl of music, if the music holders don't actually have a copyright that can be enforced, that means something, that's going to otherwise be on the dark net and just swapped around, how are they ever going to get a point where anybody says, okay, you know what, the tip jar here, we're going to give you a nickel every time that something's downloaded. I just don't think that's a very workable. I think so I'm always intrigued by y'all saying, it's going to be worked out, we got to work it out, the marketplace will work it out. But the fact of the matter is the marketplace likes free. These kids, I know they want to participate. I know they want to participate in downloading music, but I think they want to participate because it's free. That's a huge part of it, I think.
I would actually disagree. But the problem is where you're moving with that is a compulsory license, because you don't also get something free. The suggestion I hear is somehow all these other people ought to be paying, other people, participants in the market from the commercial side should be paying something. And if you do that, then what do they get? They get a compulsory license. So that's the problem with pointing to the people who are making devices. iPod is a good example. It hopefully is making money. It may not be, for the record, I don't know the breakdown of the 99 cents. I'm pretty confident, although I can't say personally, but I'm pretty confident Apple doesn't make money on the songs. This is a difficult balance in the marketplace. And the problem that I have with saying that all those other participants in the commercial marketplace who are providing services that are used for lots of other things ought to be paying something, the only way I see that works is if they get something in return, which is a compulsory license. They don't need to be worried about getting sued by it when they can offer all
It
the
could be a
music.
voluntary system, the way
Well, no, that's
Jason's
yeah.
saying. But how does anybody ever agree to let the content owners into the voluntary licensing scheme if they don't have to do it? Right now, they like it the way it is. It doesn't matter that it's.
So there are two problems that we're addressing. This is part of what makes it complex. There are the vendors, and then there are the users, right? So the voluntary collective license is about the users. It's about the music fans. For the vendors, I mean, you have the Grokster case, and now we have the sort of the fallout of that, and we'll see what happens in terms of the intermediaries and what I mean. But if so take the premise that we convince lots of music fans to sign up to get a free peer-to-peer pass, right?
Get out of jail free.
Yeah. If there are millions of those people, there will be vendors who will provide them with the easy means to get those licenses and the ways to use it. In other words, ISPs, if they say, oh my God, well, there are all these millions of people who need these licenses and there already are subscribers, we can provide it for an extra $2 a month or $5 a month or $10 a month or something like that. And I think the market will work at that piece of it, right? And then now under the Grosser case, if they do anything to induce other kinds of stuff, then they could in fact fall prey to liability potentially, right? We'd have to work out where that would be in the law, but that's definitely a risk they run if they were to go a different way. In terms of the users, I mean, and this is a very complex problem, and I don't pretend to have all the answers, but there are lots of systems in the marketplace that have sort of come around social norms, like what is normative. So for instance, if you think about cable, right? A lot of people have had cable for decades, right? When cable first came out, we had over-the-air broadcasting, and we had cable, and people signed up for cable, and it sort of grew. And if you think, how many people actually take advantage of most of their cable system, especially before TiVo, right? You have all these channels playing all the time that you're paying some monthly fee for that you maybe only use every once in a while, right? Even with TiVo, I can't get to everything I've TiVo'd, it's like, so, but on some level it became a norm that people should have TV, right? And that they should pay for it, and our cell phones, right? We have monthly bills now, a lot of us don't use our minutes or we go over, that there have been ways in which these things have been marketed where if a convenient service is there and all my friends have cell phones or all my friends are watching some show that's on cable or things like that, critical mass, a certain kind of network effect, right? And I'm not pretending to be any kind of marketing expert. That's why I'm a lawyer, right? But I think that then because people can find ways to get free TV without, they can go over to their friend's house to watch cable, or they can have their friend tape a show, or they can try and borrow someone's cell phone instead of using their own minutes. I mean, but it becomes a hassle, right? If you make it convenient and easy to sign up and it's a reasonable rate, I would say $5 to $10 a month is very reasonable for all the music on all the peer-to-peer, then I think, and the alternative is I could get in trouble, I could get kicked out of school, I could get sued, I could do all these things, or I just pay $5 a month. It just feels more reasonable to me. It feels like we could get a certain significant percentage of the population on board. And so I don't have a better answer to you for that. There are problems, it's hard, but I don't know that we've actually tried this particular solution, a sort of license for users that isn't tied to a specific service.
Yeah, I'm not sure what that means, not tied to a specific service. I mean,
It means you
who's
can't sue them.
providing it exactly?
It means you can't sue them. That's what it means. It means basically the RWA won't come after me. I paid my money.
Well, but that's what any of the license services are. I mean,
No, because as a user though, I can't get a
take
license.
iMesh. If you use iMesh and you can get whatever music you want, they've got all every song that you could want on that system.
I'd be surprised actually. But the point is, what if I don't want to use iMesh? Right? All I'm saying is that a user can go anywhere they want. If they don't like iMesh, they can go somewhere else.
Well, there'll be other competing services that come up.
So we differ on that. I mean, I just think it starts with the user, and the user has choice to go any software, any platform, any website. And it's a get out of jail free card, and I paid for it.
Yeah, but somebody's got to provide the service, and those services are being built now. I mean, I'm not. You have that get out of jail free card just by subscribing to a legal service and using a legal service as opposed to an illegal one. I mean, there's nobody feels threatened by using a service that's been licensed.
But they feel constrained.
Steve, let's invite some questions from the floor.
Enough of us.
Enough of us.
You get the argument.
Here at the the Duke Medical Center and also at the UNC Medical Center over in Chapel Hill, there is increasing use of music for terminal patients and other seriously ill patients. My question is, if a pay system is agreed upon as being the solution to this controversy, should music played in a hospital be excluded from payment? And I point out that this immediately raises questions about nursing homes, prisons, and a lot of other facilities. I'm primarily interested in your reaction, perhaps Steve and Jim, as to the reaction of the music industry if we exclude from payment under any system, music played specifically in a hospital environment.
For labels and artists, the exclusion already exists because we don't receive royalties for performances. So to the
Okay.
extent that there are performances being made in a hospital or something, that exemption essentially exists as a matter of law. The songwriters and music publishers have licenses through groups like ASCAP and BMI, and they generally have site licenses that aren't very expensive. I don't know how much they are, for that kind of thing. But I'm certainly not going to be the one to say no, no exclusion for terminally ill patients.
They're even more sympathetic than kittens. Is that?
Exactly. I will tell you, just to share a story. We file our individual lawsuits. We file them as John Doe suits. We don't know who we're actually filing against. It's just based on getting an IP address from people who are sharing the music on the internet. Well, one of the people, when they were identified, happened to be an elderly man who said that he had downloaded the music in order to provide a compilation or something to his wife who was dying in the hospital.
Oh, jeez.
I don't know what the chances are of us having, picked that one, but, we
How much did you
certainly
make him
got
pay?
it.
You're still
Cast a broad enough net,
still
That one
negotiating a
hit,
settlement.
yeah, right.
probably more than one.
In the back, Sylvester?
Well, I think everyone agrees that piracy affects revenues for record companies. It just seems to me that we're missing a big part of the injuries that record companies are receiving. I think a lot of it's self-inflicted, particularly due to the inefficiencies that are inherent, or not inherent, but inefficiencies that are ingrained in the record business model. For instance, we talk about 90% of albums failing and taste changing. In any other industry, if you've got like 90% failure rate, it says we need to overhaul the industry. And what the record industry does, like every 5 or 6 years, everyone swaps CEOs. But right? We swap CEOs, so you got the same guys running the companies. The fact is, there's no one there that's truly recognizing the talent. They're not investing money to pick out who's good, like to recognize the change in trends. And so you've got a bunch of people that find someone good, and everyone makes clones to fall after them. Jessica Simpson, Britney Spears, yada, 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 yada. And so when we talk about people not wanting to pay for music, I don't think it's that people don't want to pay for music. It's just so much of music right now is crap to people, right? If you look at what was good back in the day, U2, Aerosmith, Rolling Stones, those albums are still good. People are still buying them. Why? Because they're good. Nowadays, we got people that are just clones because record companies aren't spending money to recognize good talent and changing trends. I don't want to pay $15 for one song that I hear on the radio. I'd rather pay 99 cents. And so I think a lot of the harm that record companies have is self-inflicted. If you change the business model, actually find talent, recognize change in trends, people are going to pay for the music. People don't want to pay for crap, and it's not going to happen.
Yeah, I'm actually a big advocate of moving away, or at least offering alternatives to album-based models. I mean, there's no question, every business has inefficiencies that the models can get better. But I think what you'll start to see is bundles of 3 or 5 songs instead of 15 songs. But let's also take a step back. I mean, there were 45,000 albums that were made available. It's not as if there aren't a variety of albums that are being made available to people. So if you think, 40,000 of them or 44,000 of them are crap, you've still got a fair amount to choose from. But
That's not his point.
behind artists. And I think that's where record companies are getting it wrong.
The-
They're putting lots of money behind artists, and they're missing the boat. They're putting money behind the wrong people. Obviously, 90% failure rate.
Yeah, the statistics seem to be that they pick out, and again, this is from some of the articles, and I'm not, I hesitate to say this because I'm not an expert in this area. I've heard what you've had to say a million times over. In fact, when I was doing STMI, my daughter, who was, I think, about 13 at the time, says, "You don't get it, Dad. These record companies are trying to stuff the latest boy band or singing Barbie down our throats, and we're tired of it." That's when I said, "You download any of the stuff, you're dead." But the point, is that what the internet, the threat of the internet, in my view, is that it offers the opportunity to discover lots of stuff. And that's why I think that most of peer-to-peer was about discovery. I don't know. I can't prove it.
And I think following that point, that in the Ninth Circuit opinion in Grokster, one of the significant facts that supported the discussion of substantial non-infringing use of peer-to-peer software was the Wilco testimony. A rock band, Wilco, dropped by their record label, who actually used free peer-to-peer file sharing as a way to promote their band and actually become immensely popular and helped lead to another record deal.
But you see, I think that the problem, and I like the way Steve's nudging towards the solution to the problem. I'm not saying these guys aren't thinking about it, but the issue is really what I thought, and again, this is just such a personal story that it really doesn't, it's less than anecdotal, but I was in the rock business back before probably most of you were born. And I got to meet a lot of the great bands and work, but I was carrying speakers, and I wasn't anything important. But the point is that what I perceived the job of a label to do was to connect the artist with a fan base. The problem of what I perceive today, and again, this is just personal, I could be 100% wrong, but what I perceive is finding that 3%. And as Steve said, we only get a few. It's like the spice ship of the old Dutch West Indies. You'd send 5 or 6 ships out, and if only one came back, you made your fortune. The problem is none of them are coming back in that way anymore. It's a that's why I say this is a lot of business model issue. And they're not, the record labels aren't ignorant of it. It's just they came to the party late. And Edgar Bronfman, my little quote I didn't get, and I'll have to explain how to put sound in your presentation so it works, said exactly that. We came too late to the party, and the reason was we wanted to defend a business model. And who wouldn't? Who wouldn't? There's no one in this room, myself included, that if I'd been a music label executive in 1997, 98, 99, wouldn't have wanted to keep that going. As Mark Cuban said, I made $1 billion. Those of you who don't know Mark Cuban, he made $1 billion selling at the right time his .com to Yahoo, broadcast.com. He said, I bought this basketball team.
He made more than $1 billion.
Yeah, we made a lot.
5.6.
5.6. Well, I don't think he got all that 5.6. But in any event, he made a lot of money. And he said, you know what, I bought a basketball team. You know what I discovered? I discovered that the job of a head coach of a basketball team is not to win championships. It's to keep his job because it's such a well-paying job with great perks. And the record label execs made a lot of I don't have original thought in my mind, by the way. I steal them all. Fortunately, they're not copyrighted. and what Cuban said was, the music label executive's job is to keep his job because particularly in that era, it was the best paying job you could get. The perks were absolutely incredible, and they wanted to keep the model. I mean, I don't blame them. I'm just saying that, yes,
that's such an oversimplification.
Of course it is. Of course it is.
And it's an unfair one because, there's one thing in maybe not moving as quickly, and there's another thing in trying to preserve an old model. I just don't agree with it. It's just not the case. And I think that, the albums music is available. The problem is that most people aren't aware of music unless it's promoted in a certain way. Now, maybe the dollars that are being spent on promotion aren't, as well spent as they could be or something. And that's something, but that's always existed in the record industry. That's not something that's new all of a sudden in the last 5 or 6 years. That's always the case. Sometimes you spend on things that don't pan out, and other times you do. If you look at actually what's interesting is that if you look at usage of P2P, I know there's a lot of this. Nice conceptual, theoretical talk about how it's used mainly for promoting and exploring. But if you actually look at usage, it's predominantly of the top things that are the sellers. It tracks almost Exactly. So there's no question but that for some people it's used for exploring, and if it truly is used for exploring, you could figure out a model where people could listen once or twice as an exploration and then truly had to buy it if they liked it. Unfortunately, that's not the way, the services
Can I just,
work.
I want to
Let's-
let me just make the final
Jim,
point to this.
Jim, no.
Okay.
Well, no, go make a point. And
Yeah, no, just
let's hope-
very quickly. No, but where I was going, and I didn't quite get there because Steve rightly interrupted me, was that there's a different model. I keep looking, we're going to promote this album and sell it. How about turning it around, which is a different kind of user participation? Figuring out what individual users want. The power's there in heuristic software, and delivering to users the music they want, as opposed to saying, all right, we've got these great executives in the sky who are going to pick these 6 bands to really push.
They do that. They do that.
They do.
Yes.
They do use
it.
heuristics and deliver to
They do it.
individuals. I don't think.
They monitor P2P services and sometimes for that. I mean, they do it.
If you want
they
to
don't pay
line
for
up
that.
in the queue to speak, get your hands up where I can see them. Here's one over here.
Jump in. Just to start off with, I just want to say I learned everything I know about music from Napster 1.0, and it actually I've spent a lot of money in the music industry since then. And one of the things I want to throw out, just to kind of a technological standpoint, is I really appreciated Jason's presentation. He actually brought up micro content or micro payment in his presentation, even though it didn't get talked about in court. And I'm really sad that's not an underlying part of this discussion here, because there's actually one of the fascinating things about iTunes even is that Visa credit card company is making more off that transaction than Apple is when it goes on. And as a content creator, and I've been in the web industry since like the early 90s when it was first going on, we were waiting like any day now somebody's going to come up with a micro content solution that's going to allow us to actually make money as content creators. And over a decade later, we're still waiting for it. And I'm really sad because, I mean, it feels like this is a technical discussion, but the RIA is participating in a very big technical discussion around DRM right now, which I see as a reactive solution to this problem rather than taking a proactive stance, which is to create infrastructure to allow content creators and consumers to collaborate in a financial capacity rather than blocking the collaboration through DRM. And the thing that's funny is that DRM is actually not a technically feasible solution. I mean, from a technical standpoint, it actually is impossible to successfully achieve. But actually allowing people to exchange money is something we've been doing since the beginning of time. But our financial infrastructure right now is based even the web or internet. And that we need to have content creator organizations such as RIA have the clout to go and negotiate with financial institutions to build the infrastructure to make this new economy work. And the fact that you all aren't taking a proactive approach, rather you're taking a stance of blocking collaboration is really frustrating. I wonder if you could respond to that.
Yeah, a couple of things. One is I just disagree fundamentally about blocking. I mean, you have some companies that are experimenting with certain kinds of DRMs on physical products, for example, and other companies who don't agree with it and aren't doing it. There's no industry position about what kind of DRM and what not. But the thing to recognize, I think, if you look back historically, is that the record industry is built around people who know music and try and find talent, not people who come up with the formats. I mean, it wasn't the record industry that came up with with vinyl, cassette, 8-track, CD, or anything else. And it's really the technology companies that need to come to the industry with a product that works and have it made available. And I think that that's happening now. There are companies that are working on it, and there are companies that are working on things that are very similar to what you're saying.
It requires the content community to actually take a stance on that. I feel like that's your voice as speakers for that community to
Yeah,
play a role in that conversation.
unfortunately, there's this little thing called the antitrust
Yeah.
laws, and I don't look very good in orange. So,
Let's take this question here.
To me, I sort of have a disconnect of the conversations that are going on. I mean, I used to be in the automotive industry, and a lot of people complain that the U.S. automakers are mismanaged. They complain that the products are pieces of crap, but that doesn't mean I get to steal a Chevy. And so, I mean, for everybody who doesn't like the fact that the music industry wants to assert the rights of those who choose to assert their copyrights, and uses the excuse that, well, they're mismanaged, I mean, one has nothing to do with the other.
You're missing the point. I've never said that gives anybody an excuse to
I'm
download.
just referring to some of the things I've heard all around.
Oh, no, there are people who say that, and I think they're flat wrong. What I was saying is that, and I'll say it again, it is wrong to download other people's copyrighted material without authorization unless it's a fair use somehow, and generally it isn't. The point is, when talking about mismanagement, it has to do with misfocus of energies that doesn't benefit anybody. Again, not saying that people shouldn't assert their legal rights, but to blame, publicly blame everything. I have a problem with my life which is when something goes wrong, I tend to look for somebody else to blame for it. And that's my concern, and what I saw in the late 90s and early part of this new millennium was blaming peer-to-peer for everything.
And let me finish, please.
So I'm sorry, I apologize, Merle, I thought you were.
I mean, and it goes back also to the comment about the lawsuits. Now, you've got your right to assert, you can assert your rights. And the people I knew before the lawsuits were asserted that were doing the downloading, the response was, and I'm a patent lawyer, not a copyright lawyer, but I do know the basics of copyright law, and they would look at me with a straight face and say, it must be legal to download because everybody I know is doing it, and nobody has ever gotten in trouble for it. Those attitudes changed completely once there was all of the publicity on the lawsuits. I have to agree that from an educational standpoint, nothing until the lawsuits was making a dent in the people I knew who were doing the Napster downloads and just saying, well, everybody's doing it. Everybody knows everybody's doing it. Nothing's happening. It must be legal.
Unfortunately, the statistics that I've seen from Big Champagne, who a lot of the IT industry trusts, show that just not the opposite, but it hasn't made a dent, and the numbers keep increasing.
Yeah, that's wrong, and for a couple of reasons. One, Big Champagne is looking at file sharing across everything: porn, video, software. It's not a music
They've moved
thing.
from music
They
to
they also measure not by actual activity, but if you just have an application that's on there that you put 3 years ago that just automatically starts running when the computer does, it counts you as an active user. So that data, you've just got to disregard some data that's just not put together very well. The statistic that we find most relevant, and I don't know which way it cuts, but basically, if you looked at P2P growth, it was tracking exactly with broadband for a long time. And when we started the lawsuits, it essentially leveled off while broadband continued to spike up. And for us, that demonstrated that the lawsuits were having some effect, and there was a change in public opinion and people understanding what exactly, was going on. I mean, nobody thinks that just because you file lawsuits that everybody's going to stop doing it right away, but it has had some effect.
Yeah, the one thing let me just add quickly that I would say though that people have gone to the darknet instead of peer-to-peer.
Are there additional people in the crowd who want to say something before we close down? It's David?
My question, I guess, is for Mr. Marks, and I guess I can sort of apologize because you seem like you've been getting a lot of arrows, but I know one smart guy who made the gave the analogy of sort of the business model problems and noted that copyright protection for these things didn't even exist until like 1971, 70, something like that.
Sound recordings?
Oh, you mean copyright protection for sound recordings?
Right.
Yeah, 1972.
72, sorry,
Right.
pardon me. And sort of, this smart guy gave the analogy of something like the Grateful Dead, who learned how to basically create a culture of which people would follow and buy all sorts of ancillary products outside of the actual CDs or something like that. And somebody else made the comment that, this sort of model they were late coming to the game, but it was sort of in their face at the same time. The Grateful Dead was immensely successful. So how would you respond to that?
Well, I think that you're seeing new models like that. I mean, you have laws that constrain the revenue streams to essentially a reproduction and distribution right. And you're now seeing deals between some labels and artists that are exactly that. Korn and EMI did a deal like that. Robbie Williams did a deal like that. But as I forgot who noted it, but somebody noted that the artists aren't exactly the artist lawyers. I mean, most of them say over my dead body. I mean, you're not
leverage at all.
You're not right.
They're
You're
not
not touching
sure.
my merchandise or touring or any other revenue. So it's
We're starting this right now.
So.
There's a certain amount of gravity to all this. It's not like we just came down from Mars and said, okay, let's start a new record business.
Right.
There is
Right.
this entrenched rights that are grown up. And one thing I will say, Fendi, I didn't really come here thinking I was going to end up agreeing with you on everything, because I have lots of things with record labels I disagree with. And, I won't pile on.
I have to say, Steve has done a terrific job of responding and
Well, the
not
one thing,
throwing anything at me.
The one thing I was going to say is that when everybody says the record labels came to the party late, well, they did come late. It may have been partly that they were just coming. this thing will go away, it'll pass, it's a fad or something like that. Maybe there was some actual naivety along those lines when it first started. But there's also this question, the free services didn't really have to worry about things like whether they have the rights to put this stuff on their services. Whereas record companies who have contracts and have grants of rights have to be sure they don't exceed those rights. And there are thousands of artists, individual rights holders, samples, producers, songwriters, many of whom signed contracts in an era when digital rights hadn't been contemplated.
That's a great point.
It's just, it is one of the reasons there was a lag. Maybe it's not the only reason there was a lag, but to say that the record companies, the minute Napster came up, should have immediately gone straight in with their own competing service that was free, it took them a while to work it out. And I think that's somewhat understandable.
It's also digitizing a catalog in a way that has to get approval, for example, by an artist who wants it to be of a certain quality. And, it's a very interesting thing in this industry where you have essentially the new product. I mean, if you look at MP3 or even in iTunes as new product, the quality is actually going down.
Yeah.
Which is it's an interesting fact, isn't it? That less quality went skyrocketed, and people, forget before people really realized it was illegal, because a lot of people didn't understand that, which was, and education is important. But I do want to disagree a little bit, because I was there and we were begging them in '98 and had the system ready to do. My view of it, and it's my personal view, was that the record label executives were doing some of this, and they were also saying, no, we don't want any outsider to do this. We, the labels, are going to do it. And they stalled, and then got their own services up, which were disasters commercially, which did not work at all. And my belief is that Apple was ready long before that, and they were made to crawl over broken glass before they got there. And I understand the antitrust issue, which is that is a problem. The antitrust issue, don't take that light. I mean, we were meeting in SDMI out in Los Angeles at the Century Plaza Hotel, and the FBI had suites of rooms. They were investigating the music industry, not for SDMI. We were hoping no, but they were doing it for something else. So there are, in defense of Steve and what Bertis is saying, is there are problems. I still think there are other issues, but there are legal problems that they are confronted with and have to be dealt with.
So I think we're probably at the point at which we have to end what has been a great afternoon, following a great morning. If I understand the gist of what was said by the members of this panel, it is to work like hell on your live show and tour. And I'm
Get on MySpace.
grateful to the 5 people here who have spent their afternoon with us and shared as much knowledge about this industry as I think any 5 people can have. Thanks very much to the panel.
That concludes the regular programming for the symposium.